matter. And you all need to know this right up front. If you don't have your kids back in your home yet, your federal lawsuit isn't going to do the trick for you. In fact, if you set out allegations or a prayer for relief saying, they did all these horrible things, they lied about me, they cheated, they suppressed evidence, they fabricated evidence, and they took my child, and judge, give me my child back. The federal courts have no jurisdiction to do that. In fact, what they will do, even if you pled other claims that are supported, the judge will dismiss your case as a collateral attack on a state court judgment. So when you're contemplating one of these lawsuits, remember, all you can get is money. That's it. You can't get your child, you can't get those years lost back. You're not going to get any of that. That's just the way our system works. What happens is, if, say, for example, you break your arm. You know, a judge or jury can't heal your arm. They can't give it back to you. So what we've done as a society, we recognize that because we can never really give you back what you lost, we're going to assign a money value to whatever it was that you lost. And that is all you're going to get, is money. So just resign yourself to it. One of these lawsuits is not going to get your child back. In fact, if you plead that in your complaint, you will be dismissed, I guarantee it. And if you appeal it, you'll lose on appeal. So don't do it. That's just the kiss of death.
Did you say don't plead to get your kid back?
Not in your federal case. You do not ask for your child back because that will be construed as a collateral attack on a state judgment which the federal court has absolutely no jurisdiction to deal with.
One simple question. How about if you have one child back and two? Just
questions
no,
afterwards.
Questions at the end.
Oh, thanks. Sorry.
It's all right. I understand it's hard.
It was just like a point.
I know, I get it.
Write them down.
Yeah, in fact, what you ought to do is write down, if you have questions as we're going along, write down the general subject matter, the question, and I promise you, we may not get to all of them, but we will try to deal with it at the end. Okay, just one last thing on that point. If you do end up facing a challenge to your federal civil rights lawsuit, especially if you file a federal instead of state court, probably what will happen is the social workers of the county will cook up a motion based on either Younger abstention or Rooker-Feldman. Both of those are potentially dealt with, and we have full briefing that was recently posted on the FAGA group site where we dealt with both Younger abstention doctrine and Rooker-Feldman doctrine, and we were successful on both motions. So those are there, and if I haven't already posted the orders, because the judges, at least in federal court, not always in state court, but in federal court, they'll do their own independent research, and sometimes their briefing that supports their order is better than ours, so we'll post that instead. So if I haven't already posted those, I will, and I'll look and make sure. Okay, so we're going to move into, and we touched on a little bit, the two basic areas that you're going to be dealing with if you're filing a lawsuit. And one, you already know, it's going to be warrantless removal. That's where they do not have an emergency, but they don't get a court order either, and they then remove your child either from the home or from school or daycare or wherever they remove the child from. The second class of cases that we file are where the detention was prolonged or initiated based on lies, fabricated evidence, or suppressed evidence. Now there's a little bit of crossover there, because if they lie and they do get a warrant based on the lies, that's the same as if they got no warrant at all. So it's going to end up being a Fourth Amendment violation for the child, because remember, I may not have said this, you may not remember, but Fourth Amendment claims are personal, meaning the person that sees, in these cases it would be the child, the person that sees has a Fourth Amendment right. The parent, on the other hand, they're not seized, they're still at home doing what they do, they just lost their child. They don't have a Fourth Amendment right. Remember, it's personal. They have a 14th Amendment right to continued association with their child and custody of their child. So the way we analyze these two things is a little bit different, because if your child is back in your care, you'll need to get an attorney to actually press their claim, because you can't represent them without being licensed. So if you have your child back in your care, they have a Fourth and a 14th Amendment right that would have been violated by the social worker that lied to grab them, or by the social worker that grabbed them without a warrant. Two distinct claims. From your perspective as the parent, you only have a 14th Amendment right that you're going to be pursuing, but there's two different aspects. One is going to be sort of general social worker lied about me throughout the process, or suppressed evidence, or didn't follow some statute that they're constitutionally required to follow. And then you'll have the warrant aspect, which is they either seized my child without a warrant, or they lied to get a warrant, or they lied to keep the child once they detained them. Okay,
Does that include affidavits for like 5-day hold?
Okay, so hold it. So basically, as a parent pursuing your 14th Amendment right, you'll have two different counts if there was a seizure. Count one will obviously be the warrantless removal, or unwarranted removal is probably the better way to phrase it, because an unwarranted removal would include a seizure of the child without a warrant, as well as the seizure of the child based on a fraudulently obtained warrant. So it's an unwarranted seizure. Your other count would be your 14th Amendment right to the extent it was violated after the seizure by any misconduct, that appears in the case. And that would include lying, fabricating, perjury, using duress to obtain evidence, that sort of thing. So that's the structure of your complaint. And again, recognize that if you do have your child back and you want to pursue a claim for the child, you're going to have to get an attorney for that, because you cannot represent the child. One thing there, sort of a caveat, I guess, is that on the federal claims, the statute of limitations for the child is tolled, meaning it doesn't run, until the child turns 18, and from that point forward, the child has 2 years to go ahead and pursue their rights. As far as the state law claims go, it's a different rule altogether. Once the child is out of state care, then whichever is the custodial parent, that right inures to them, and if they don't press it, the child loses the right, it's waived, it's gone. So a lot of times when we see a child coming in, and they've been in one of their parents' custody already for a year, year and a half, then we don't even look at state law claims unless there's something that will get us tolling there, but usually it's a difficult call. Write it down. All right. Okay. In a separate category of warrants, whether it's a warrantless removal or a warrantless interrogation, or warrantless entry into your home, or warrantless medical examination of your child. There's a whole bunch of personal rights that are covered by, from the child's perspective, the Fourth Amendment, from the parent's perspective, the 14th Amendment. Any right that inures to the benefit of your child under the Fourth Amendment, while they are under the age of 18, while they're the age of minority, is your right to press as their parents. Remember, as their parent, you're responsible for their care, companionship, control, upbringing, whether it be religious or whatever, until they turn 18. You are the one that's in charge of that. So what that means in the context of our litigation, the stuff that we're all going to be doing here, is that if the child had a right that was violated, you have an equal, reciprocal, and corollary right as the parent under the 14th Amendment. Okay? So what that means, a good concrete example is if a social worker comes into your home because, you had a pissed off neighbor that called because your dog pooped in their yard or whatever, social worker comes in and says, I heard you're abusing your child. I need to see their body. And they turn to Johnny and they say, Johnny, drop your pants. They need a warrant to do that. That is an invasive examination unless they have reasonable and articulable evidence from a credible source to support the proposition that there is an absolute emergency, and if they cannot avert the emergency, they got to act on it right now. They can't take 2 hours to go get a warrant. Unless those facts exist, they can't strip down Johnny and look at his CPU. It just can't be done. So those are things that we see frequently. Another thing that we see frequently is where similar allegations. Maybe you had a dispute with your pediatrician over, I don't know, a heart condition, let's say. That's a great example. And you have a dispute. You want a second opinion. Pediatrician takes it personally, gets pissed off, calls in a mandated report. Social services comes out. Unless they get a warrant, they can't examine your child. It just can't be done. They can't do it at the doctor's office. They can't do it in your home. They can't do it anywhere unless, and this is where it gets kind of dicey, because the definition in the Ninth Circuit anyway of exigency until recently has been a little bit wobbly. But exigency, what that means is that there is an emergency right now. There is an imminent, meaning immediate, instantaneous, about to happen. There's an emergency right now that requires the social worker to act, and if they don't, the child will either be suffer severe bodily injury or death. So it's got to be serious. It's got to be severe bodily injury or death. And if they can't prove, when you sue them, if they can't prove that that child was going to suffer severe bodily injury or death in the 2 hours it would have taken them to get a warrant, you've got a claim that's going to go to the jury. They will not defeat you on summary judgment.